Good evening. Thanks so much for tuning into Mirror Now. I'm Aarti Subramaniam. You're watching this very special edition where we're going to tell you about the Enforcement Directorate, India's premier agency that is investigating crores and crores worth of financial misdeeds, and what the Supreme Court has to say about them and the very future of this agency. Use the PMLA reasonably, otherwise the act will lose relevance. These were the strong remarks by the top court, warning the central agency, that's the Enforcement Directorate, against the indiscriminate use of the Prevention of Money Laundering Act. The bench has asserted that the act cannot be misused and weaponized to put people behind bars. The Supreme Court has made these scathing observations while hearing two matters where the petitioners have been accused under the PMLA. Now, this case has once again put the Enforcement Directorate under the scanner. Remember, in the past, the central agency has been accused of using this act as a weapon to target and intimidate opposition leaders. In fact, the central agency has also been pulled up repeatedly by the apex court for its investigation. Okay, my colleague Meenakshi Bhanja tracking the Supreme Court, all the developments there. Meenakshi, just summarize for our viewers some of the tough talk that the Supreme Court issued to the Enforcement Directorate today.
Well, that's right. You see, this assumes a lot of import because often we have seen sharp criticism coming in from political circles to lawyers who go on to argue such cases for the accused about the purported misuse of PMLA. And that message today being underlined and reinforced somewhere by the Supreme Court. Of course, we're talking about two disparate matters. As of now, the Supreme Court has intervened in one of the matters, but the scathing nature of these observations assumes a lot of import, where today, no less than Honorable Chief Justice of India-led bench of the Supreme Court has gone ahead and made a scathing observation about how the PMLA, if used indiscriminately in cases involving around 10,000 to 100 rupee cases, could lead to dilution of the act itself. So that's a scathing observation coming from the Supreme Court, where Honorable Chief Justice of India went ahead and said, and I quote, "You can't put people behind bars this way. It has to be used unreasonably." Furthermore, it was another Honorable Justice Bopanna who also went ahead and made the observation, and I quote, "If you indiscriminately use PMLA, which is the Prevention of Money Laundering Act, in this way, it will lose its relevance," unquote. So these kind of observations go on to have a long-term impact, where the agencies also have to really apply their mind and see whether, when slapping of these charges against any accused in any case, when they go ahead and do something of that nature, whether there is enough evidentiary value that they have collected which justifies the slapping of these charges. That's essentially the message coming loud and clear from the Supreme Court, no less than the Honorable Chief Justice of India-led bench saying and wrapping the agencies in this case. Two disparate matters, Aarti, where the ED was involved in one case, in another case it was the CBI.
Yeah.
But the rap is collective. Of course, the Supreme Court frowning upon the loose usage of this act, and really going ahead and making these observations, expressing concern that if used in this indiscriminate manner, it could lose its relevance.
Okay, Meenakshi, thanks so much for that. I also want to go across this evening to Mirror Now's editor, Nikunj Garg. Nikunj, good evening. Thanks so much for joining us with these inputs. You know, we see the Enforcement Directorate is one of India's premier agencies. Crores and crores worth of financial fraud is investigated by this agency, and yet it has come under such scathing criticism from the Supreme Court. Why is it so? Why is it that the Enforcement Directorate is such an organization that in many ways finds its reputation tarnished?
Well, Aarti, there are multiple aspects to this entire matter. First of all, this is a caution, this is a warning, this is a timely reminder from the Supreme Court, that to none less than Chief Justice of India's bench, that special provisions of the law, remember, Prevention of Money Laundering Act is not a routine act, it's a special act. It is not part of the Criminal Procedure Code, IPC. So it's a special act, and special acts have to be used sparingly. That is what the spirit of the act, the very spirit of the act is, or the spirit of behind such acts is. Now, when you start to use them in a routine manner, in a cavalier manner, according to the Supreme Court, and this has happened routinely in case of Enforcement Directorate particularly, not only you endanger the reputation of the agency, which you have done in this case, or according to the court repeatedly happening, but you endanger the act itself. The wisdom behind imposition of the act, or wisdom behind enacting the act itself, comes under scanner or is challenged. So the Supreme Court says that you cannot put everyone behind the bars, from 10,000 rupees to the bigger financial offences. Remember, Enforcement Directorate is the premier financial probe agency of the Union of India. There are economic offences wings also across the country now that have been set up under the state police's jurisdiction, which probe cases locally. But the premier investigative agency is the custodian also of the Prevention of Money Laundering Act, which is a central act, and ED is the custodian. Now, if both the agency and the act itself come under repeated scanner and criticism from the top court of the country, then there is something grossly wrong. And for a very long period of time, it is not just limited to the BJP regime, which is of today, but during the Congress regime also, the criticism of the central probe agencies has been, including the Enforcement Directorate, that they have been used to hound the opposition politicians. On top of it, the Supreme Court of India, led by the Chief Justice of India, says that you are using it arbitrarily. There's an indiscriminate use of the act on the private citizen. Remember, in this particular express matter, no political party or political person is involved, and therefore there are private citizens who have gone in appeal to the Supreme Court. Now, if against the private citizens, against the politicians, and against all and sundry the act is being misused, then there is a very serious concern of overall abuse of the act. Normally, under the matrix that has been designed, there should be enough provisions within the Enforcement Directorate itself to check any kind of misuse of the act. But that quite clearly seems not to be happening. That is why the courts have to caution, and that too, top court on multiple occasions has cautioned the Enforcement Directorate. High courts have routinely been cautioning in the Kerala gold smuggling case. Even the various provisions of enactment of the act were challenged. In yet another case, bails were granted when ED was stoutly opposing them. So quite clearly, both the use and the manner in which it has been applied have come under intense scanner. And that also is aggravated by the fact that if you look at the overall conviction rate under the PMLA, in last 1 decade, hardly any convictions have taken place. ED's conviction rate hovers below 20%, which I would say is extremely poor. It is worse than the local state police agencies, and these special acts are construed and applied, Aarti, only to improve the conviction rates, so that the bigger fish do not fall out of the net, and the conviction rate, overall conviction, law enforcement in such cases improves. But what we see is something to the contrary, where the special acts are actually not yielding the desired effect, but are again and again coming under the scrutiny for their adjudged misuse. And that is what is worrisome. Conviction rates remain poor, raids remain arbitrary, political misuse charge continues to stick, and on top of this, a warning comes from the Chief Justice of India's bench to the premier financial agency. So quite clearly, something is not right either with the act or its administration. I'm sure you have learned lawyers and other people joining on your panel who can probably better elucidate it on this matter. But what it appears from Supreme Court's warning is that quite clearly the application of the act is certainly not being done with enough discretion.
Okay, Nikunj, thanks so much for that. I request you to stay with us. Senior Advocate of the Supreme Court, Aryama Sundaram, also joining us this evening. Mr. Sundaram, good evening. Always appreciate you having you here on Mirror Now. I just want to take you through a statistic, and for all our viewers, a total of 13 people were convicted under the money laundering law, which was implemented about 14 years ago. This was statistics from 2019. What is the problem? Is it the law, or is it the agency that is implementing the law?
Well, I'll tell you something. We have to understand the whole thing in perspective. The reason for the annoyance or the concern of the Supreme Court was because there is a very specific purpose to the PMLA Act. There are offences which are punishable under the IPC, under the Prevention of Corruption Act, under various statutes. But it was felt that illegal activities, the proceeds from illegal activities, a person may get punished or caught for having participated in an illegal activity, but ferrets away the proceeds from it, conceals the proceeds from it, or has other people who enable him to bring it back into the system as though it is not, as though it is purely legal money. It was felt that this should be taken care of. That the people who indulge in this kind of money laundering, that's why it's laundering. It's laundering because you're making something black or illegal, making it legal or white. So the whole aim of the act was really to take money which is born of proceeds of big scams, big frauds, illegal activities like gambling and prostitution or corruption, that all these monies came out of such illegal activities, if they were in any manner sought to be legalized, whitened, brought back into the system, then anybody who had any role to play in it, whether they concealed it or assisted in doing it, or if they themselves brought in this money through other sources. So the act came in to give a specific separate punishment for this, where the punishment is up to 7 years. But more than that, the act also provided that all such properties can be confiscated, can be seized. Now, that is also a very important part of the act. Thirdly, what they did was, rather than use the normal criminal justice system and using the normal police, it was the ED which had to get in and prosecute on these. And there were special courts set up to quickly deal with such matters. Therefore, it is a very draconian law. It was brought in because it was meant to deal with a very, very serious situation. Now, when you start applying that act as a tool for blackmail, for a tool for vendetta, for a tool of whether it's political vendetta, whether it is somebody who's trying to get somebody else into trouble, and therefore for offenses which should not really be visited with the consequences of such a draconian provision, and which should be dealt with under the normal law of the land, when this act starts getting misused in those ways, two things happen. One, the unfairness, the illegality, the injustice of applying this act to persons who do not really, are not deserving, their conduct is not deserving, what they've done is not deserving of such draconian action, but they should be dealt with by the normal law of the land. And second, what happens is that the very seriousness of the act is diluted. The very fact that such a serious act, when imposed, would make a court and would make people feel that something very serious has happened, should be seriously dealt with. The person should be punished in a very strong manner. Now, all that gets watered down. You start feeling that this act is just being thrown around and being put into service for anything at all. And in which case, the whole seriousness of the act, the seriousness of what is sought to be addressed, is all watered down. And therefore, that is what the court was saying today. It's saying what you're really doing is, by misusing the act, you're watering down the very purpose of the act, the reason why the act was brought in, so that it becomes ineffectual in actual implementation. Because you're trying to stretch it too far, do things very far. You must realize one more thing this act brought in. It's what's called extraterritorial jurisdiction in a way, in that a person's assets outside the country can also be seized. And for this, there are various treaties amongst the countries which enable this to happen. So when you start using such a serious provision, such a draconian law, a departure from the normal law, a departure from the normal jurisdiction where you only usually deal with assets in your own country, when all this happens, well, it should be correctly used, sparingly used, and used where deserved, which brings out the effect, purpose, and the entire scope of the act is then given use to. Unfortunately, by being misused and misapplied and being bandied around, the whole purpose of the act is lost.
Yes, Mr. Sundaram, the phrase is follow the money, but as you were also saying, provisions of the PMLA, they are complicated. Money laundering is not a straightforward crime in that sense. Does the Enforcement Directorate and several of its officials have the kind of expertise, the kind of training to actually be dealing with these complexities?
Well, it is very complicated because in a way, if you take the very definition of money laundering, what it really amounts to is people who are concerned with concealment of illegal, proceeds of illegal activities, really, illegal gains, who are dealing with concealing, in otherwise reintroducing this money as white money, as legal money back into the economic system. So obviously you need people who are well trained, who are able to ferret this out, who are able to follow a money chain and follow it right through to see how this is brought in. It's done through companies, shell companies, in various other ways. In the old days, we used to have a very simple expression, hawala. Hawala is now become more and more finer, finer and finer. I should say it's a finesse today on this hawala, because you go from one company to another shell company to a Cayman Island company, which is held by another company, and this whole chain has to be detected. So there have to be people who are very well trained in this, who are capable of actually following this money trail and finding where it is to make it an actually effective act. Otherwise, like I said, it's just going to be an act which is thrown around. People are going to be threatened with it. And in the end, you're not going to have the convictions because you're not going to have the proof.
Mr. Sundaram, just one final question, and I really do appreciate you laying this bare for all our viewers. You mentioned the agency and this act being used against political rivals, and not just by one government, by several governments in the past. It has been done so. But you also see cases where, the PMLA is drawn in cases like that against Riya Chakrabarti. So it is, and the Supreme Court, I think, is perfectly correct in saying it's being weaponized.
Absolutely correct. It's not only used as a political rivalry. Like I said at the very beginning, it's being used for many purposes, including threatening a rival. It could be a business rival. It could be somebody else whom you have any personal animosity to, but you are able to reach out and get the AED to assist in helping you on this way. You might have been cheated because of some business transaction, but to get back at this person, you then get the ED activated and then bring in the PMLA Act to do everything else. So the ED is going to be spending half its time on dealing with matters which the normal criminal dispensation system should deal with. And you're going to be, wasting resources which are very scarce as it is, of your ED resources or people who are trained in it, to do all this kind of thing rather than really go after what the whole act was intended to do.
Okay, Mr. Aryama Sundaram, thank you so much for speaking to Mirror Now, taking time this evening. I really appreciate you joining us. Of course, the Enforcement Directorate, the PMLA, both coming under criticism from the courts and also by several opposition parties who've accused the central government of using it against them in the past. In fact, we have a reaction from the Shiv Sena to these developments in court. Let's listen to what they had to say.
We are happy with the stand taken by the Supreme Court. It was very much needed, particularly in the state of Maharashtra. The way ED has been harassing literally our ministers, our MPs, our MLAs, and even our ex-MLAs, MPs, and sending them notices, calling them every now and then. And this is a type of misuse of the central agencies, investigative agencies, which the central government is resorting to just because they couldn't form, the BJP couldn't form a government in Maharashtra. And this is how they are high-handed behavior of the central government. So this was very much needed. And I think that the central government learns a lesson from this.
Okay, going back to Mirror Now's editor, Nikunj Garg. Nikunj, the word caged parrot was very famously used for the CBI. Has the Enforcement Directorate also now become this tool which is being used by agencies, which is being used by the central government? And in fact, it's only perhaps a matter of time before such a phrase comes to be used for the Enforcement Directorate as well.
Well, rather infamously used, I must say. The fact remains that the charge from the opposition, and a very robust charge, and not without reason, most neutral observers, most independent observers would say, has been this, what you are mentioning, that the Enforcement Directorate, rather than being an independent financial probe agency, has been acting as a tool in the hands of the central government, whosoever is in power, whosoever runs the dispensation, and has been targeting the opposition political parties. And that charge, unfortunately, PMLA came into force somewhere around 2008, the amended PMLA that is, in which many call it draconian powers were given to the Enforcement Directorate, and it was made the custodian of the PMLA from the central government side. Since then, the charge has only intensified, that it has been used to target political rivals and people, as Mr. Aryama Sundaram was pointing at, and people who are inconvenient to you in certain dealings or who are not, so to say, falling in line with powers that be. Now, this is a charge that is not going to go away unless the probe agency itself makes up its mind and decides that the application of the act has to be application has to be with great amount of discretion and in a completely justified manner, justified not only in the way the agency sees it, but in the manner in the judicial forum see it. Remember, when an act and the behavior of an agency started to be criticized from lower courts to the top court of the country, and that too by a bench headed by the Chief Justice of India, that is a time for serious introspection for anybody who's on the other side of the fence. So in this case, Additional Solicitor General was representing the probe agencies or agency, and he came in for this kind of criticism. This quite clearly is a reflection on the way the agency has functioned so far, on the applicability and the application of Prevention of Money Laundering Act. And quite clearly, it is a moment when agencies can pause and introspect as to what has gone wrong and what can be remedied and what can be the correct course of action to be taken in future.
Thanks so much for that. Now, Nikunj, of course, was referring to the fact that the Enforcement Directorate has come under criticism from the highest court to the lowest court. For our viewers, I just want to tell you some quotable quotes, some of the things that the Supreme Court has said regarding the Enforcement Directorate and its investigation over several years. Now, sample this in August 2021 in a case dealing to prosecuting MPs and MLAs. The Supreme Court said if there is something in the case, then you should file a charge sheet. But if you do not find anything, the case should be closed. Don't keep the sword hanging. Very, very crucial comment saying don't keep the sword hanging. It's something that we have seen for several years, especially in political cases. There is no outcome. There is no justice, so to speak. The cases just keep dragging on and then later used for political purposes. Now, the Supreme Court in that same case orally also observing that the ED reports are very inconclusive and no reasons given for not filing charge sheets for 10 to 15 years. The reason for delay is not mentioned in the report. This is, of course, the Supreme Court in that same case pulling up the Enforcement Directorate for the glacial pace of several probes. In 2019, in a case where the Enforcement Directorate was challenging bail to Congress leader D.K. Shivakumar, the court said this petition seems to be a case of cut, copy, paste from the petition against P. Chidambaram. Can you imagine that? The Enforcement Directorate was accused by the Supreme Court of cut, copying, pasting against, in fact, the former Home Minister. Now, another comment in the same case was educate and instruct the officials that our judgments are not to be played with. This is not the way people of the country should be treated. So some glaring criticism coming in, some scathing comments coming in from the Supreme Court for the Enforcement Directorate. Okay, and finally, in another case, in May 2011, in a black money case against Hassan Ali, the Supreme Court has said that the case was registered in 2007 and custodial interrogation takes place only in 2011. What is the speed? What is going on in this country? You started the investigation only after persistent queries by this court. Now, this is what the Supreme Court has said, and this is not just perhaps limited to one case where we have seen it drag out the investigation, the prosecution, several cases being dragged out, especially those which have political overtones to it. That's all we have time for on this special story that we brought you this evening. Slipping into a short break. Stay tuned.